My name is David Lopez, co-dean of Rutgers Law School in Newark, New Jersey, and this is The Power of Attorney. Today, it is my profound honor to have as my guest Professor David Noll, a professor of administrative law and civil procedure. David, greetings.
Great to be here. It's good to be here for this double David episode.
Yes, we have to try to make sure we don't confuse ourselves on this, right? So just sort of as sort of a setup, I'm going to brag a little bit about Professor Noll. Professor Noll this year was voted by our students as the faculty speaker at the commencement. And I have to say, Professor Noll knocked it out of the park. He also was selected to be the David Stauffer Lecturer. The Stauffer Lecture is just an incredible honor that we bestow upon one faculty member every year to talk to the Rutgers alumni and the broader legal community. And we're still hoping that we're going to be able to hear what you have to say in that context as well. But I guess in a nutshell, this guy is absolutely incredible. He's very beloved by the students. He's incredibly well respected by the faculty. Anything you want to add to that, David?
No, I'm just embarrassed by the description you've given of me.
Let's start by talking about the pandemic.
So it was an absolutely wild semester, incredibly challenging, but also really rewarding to see the way that everybody switched to learning online. For folks who don't know, what happened at our law school was that the coronavirus pandemic really hit right around spring break. And so for the first half of the spring semester, I was teaching an ordinary civil procedure class, which in itself is always an extremely challenging and extremely rewarding experience because it's really the first class that students have in the 1L year where they get to explore the nuts and bolts of how the litigation system works. How do I file a lawsuit? How do I defend a lawsuit? What are the steps that I go through before a case gets to trial? How do I get discovery from the other side, right? If I want to see the other side's emails, what's the process for doing that? In my class, we start by walking through the federal rules of civil procedure, which are the rules that apply to proceedings in federal district courts. And we had just about walked through the life cycle of a civil case when the pandemic hit, and we switched to online learning. And I have to be honest, like almost everybody else who was a law professor, I hadn't put a lot of thought into how to teach a class online and how everything would work. A colleague, Agnieszka McPeak, is an expert at online learning. And when she was a student at Tulane Law School, she actually was forced to go online because Hurricane Katrina hit Tulane. She put together just an incredibly helpful 10-page guide that explained her approach to online teaching. And I more or less followed what she did. Her insight was that compared to a usual classroom where what you're trying to do as a professor is foster discussion and use cases as a way of unpacking the arguments and the strategy that's at issue in a case, we learn differently online. Our attention span is different. We need a different mix of how we absorb information and how we process information and how we respond actively to it. So what I tended to do was, I joked with the students that I was setting up a YouTube channel, right? I would make sort of shorter videos that would give them the basics. And then what's really great about the online experience is that there's more opportunities for actually doing stuff. So one week, maybe they would write a little memorandum that was imitating something that you would do in litigation. Other weeks, there would be little quizzes that they would fill in. And one of the unexpected benefits of the switch to online learning is that you actually do a lot more work as a student that approximates what you would do out in practice than you do in a traditional doctrinal class. So that was really great to see. And as a professor, it interestingly allowed me to keep much closer tabs on how students were doing than sort of a traditional classroom lecture class. I really felt that I learned a lot from being forced to do the class online and really thinking about different approaches to teaching and different ways to master the skills that the students are going to be putting into practice in a few short years.
That's wonderful. How many students were in your civil procedure class?
So I had a 65-person class
That's big.
semester, right? So we did things like, there would be office hours where smaller numbers of students could show up and discuss the readings. Every now and then we would do sort of a big Zoom class where, on my screen we had 65 people. And, one of the other nice things about it is that you get to know the students in a kind of a different way than you do in a traditional podium class. I'm a pretty animated teacher. When I teach, I write stuff on the whiteboard, I walk around, we split into groups and I eavesdrop on what the students are saying. But even then, you don't get to know them personally. And I felt like one of the nice things about online teaching is that, right, because you're interacting in such a personal way with students, I really developed a personal connection above and beyond the very strong personal connection that you develop teaching 1L law school classes ordinarily.
I think one of the things that you're very well known for is how you take complex and sometimes seemingly dry concepts like subject matter jurisdiction, for instance, and make them accessible and interesting for the students.
One of the challenges of teaching procedure is that it's easily the most technical first-year class. As I say to the students on the first day of class, even before you went to law school, you probably knew that when you click I agree on iTunes, you're creating an enforceable contract, and that if you breach the contract, bad things are going to happen. But unless you have been involved with a college disciplinary board, or unless you've been involved in litigation or the criminal justice system, most of us don't really know what it's like for a court to work. We have these inchoate notions of what's fair and the way that courts should operate. But what's exciting about the civil procedure class and what's exciting about administrative law is that you're peeling back the curtain and you're looking at how these institutions operate on a day-to-day level. And they really raise just fundamental questions about law. Right? What is a fair process? Should we be using the same process when you have a $10 million breach of contract dispute as we do when someone brings a Title IX claim alleging sexual harassment? To what extent do we want judges actively managing cases as opposed to simply waiting for the parties to develop the cases? How much are we willing to spend on dispute resolution? What does it mean to have a fair judge? What does it mean to have a good record for a decision? And so, there's these deep themes that run through the classes that once you're able to master the technical materials, really, resonate with the students and raise these hugely important questions about law.
And one of the things I like about our hallway discussions is that you see procedure as really a very deep conversation about fairness. And that's a conversation that we start having, when we're young children. And we have all these different processes for deciding who gets to do what, when, and how. And, these are just like really deep, fundamental questions. And I think when you start thinking of procedure in terms of whether it creates a fair process, and, that certainly is a very broad concept, but it's an important one. And what I like about the conversations and what I hear about your approach is that you always focus on that.
Yeah, and it really runs throughout the law. And so, when you learn procedure, when you learn how the legal system works, that is, that's something that you can take with you if you become a public defender. It's something you can take with you if you go work for a big law firm in Manhattan. It's just one of these tools that, in a sense, defines what it is to be a lawyer, right? We care about process. We want to get the process right. But also as advocates, we use process to fight for the goals that our clients are trying to accomplish.
And one of the things that I know that we've just discussed before, because we have a shared interest, is the whole issue of compelled arbitration. Why is the whole issue of whether something is in a public form or in a private arbitral form important? Do you want to just talk about that briefly? Because I know you have a deep interest in that topic.
Yeah, sure. Let me just take a step back for our listeners who aren't lawyers. When we talk about arbitration, we're saying that usually there will be an agreement or a contract. And the contract will say, if we have a problem, if I want to sue you, or if you want to sue me, between the two of us, we agree not to assert that claim in court, but instead to take it to a private party, an arbitrator, who is going to resolve our controversy. So, there's a very long history of arbitration. It goes back hundreds and hundreds of years, and there's a lot of things to like about it, right? If you're importing widgets and you are worried that there's going to be a dispute about whether the widgets are high quality or conform to what you agreed to or not, arbitration allows you to say, instead of having a judge decide this, we're going to have an expert in widgets decide this. And the arbitrator doesn't necessarily have to follow court procedures, though, right? The arbitrator can give you a quick decision. Towards the turn of the 20th century, there were a number of statutes enacted which solidified the legal basis for arbitration. One of the events that triggered the enactment of those arbitration laws was following the financial panic in the first decade of the 20th century. There was a lot of perishable goods that were just sitting in ports that went bad because people couldn't figure out who was entitled to them before a court could render a decision. So the story of arbitration is that it's expanded from this domain, right? Traditionally, arbitration is used in commercial contracts. It's used by merchants. And arbitration has expanded to include more and more types of claims. And since then, the category of disputes that you can send to arbitration has grown quite a lot. So you might say, why should we worry about this if arbitration is such a great dispute resolution system? And an exercise I like to do with the students is I say, I usually do this over the weekend or something. I say, go out and find a couple arbitration contracts that you've agreed to. And they're inevitably in the fine print of contracts that people agree to when they buy a cell phone or sign up for iTunes or take a job. They're inevitably drafted by a party that is trying to insulate itself from legal liability. And one of the themes of my scholarship is that when litigation are serving a public regulatory function, even if arbitration might be a great way of resolving commercial disputes, taking disputes that serve a public regulatory function and putting them into arbitration has all kinds of effects, negative effects that we might worry about. So, right, the classic example is that there's a harasser at a workplace and who's serially harassing people, and every time that somebody brings a claim to HR or raises a complaint, that is shunted off into arbitration, and so people are left susceptible, vulnerable to this person. Whereas if the claims had proceeded in court, they would become public. There's other more complicated effects. Arbitration affects the incentives for attorneys to bring lawsuits. It affects the flow of information to state and federal regulators that my scholarship explores. But it's really right. It's this very interesting tension between what we look to lawsuits to do and the way that arbitration thinks about the structure of a legal dispute.
And I think with your sexual harassment example, I think it's important to remember that the victim often believes that she or he is the only victim, and they don't recognize that other people had been through that or that it could have been addressed earlier by the company. And Absolutely. So I think you have this sort of lack of internal transparency that really leads to, potentially more harassment and doesn't really allow for deterrence or prevention.
It illustrates that basic point that procedure is power. The Civil Rights Act creates very strong anti-discrimination protections. Just this week, the Supreme Court ruled that the Civil Rights Act prohibition of employment discrimination on the basis of sex includes discrimination on the basis of LGBT status. But none of that really matters if the process for enforcing those rights isn't adequate.
Yep. Okay, so now that you've made civil procedure interesting to the world, I want to turn our attention to administrative law. But before we do that, I want to kind of close the loop on the virtual education, just because I think that your approach to teaching really shows just a tremendous amount of love and care for your students. And I think that was really reflected recently when the students voted you as the faculty speaker for commencement And it was a very unusual year indeed because of the pandemic. And I want to set the scenario, but I really want to talk about some of what you talked about, because I thought the way you did this was both very captivating, but also very powerful. It wasn't just a gimmick. So imagine David Noll, and he's sitting in a smoking jacket in front of a fireplace, and there's the music from Masterpiece Theater, and that's how it starts off. And then he had some other great visuals of life during the pandemic, being at home with his family, and really, started it out, and I think in a very humorous way, just about how the pandemic has really kind of upended our lives and our world. But then you just sort of went in for the kill, so to speak, and you were really talking about the impact of the pandemic on the role of the lawyers and what our newly minted Rutgers law graduates needed to think about. Why don't you pick it up from there so I don't continue to butcher what was just...
Sure. I'll give you the backstory. This is a video that was shown at our virtual commencement because we, of course, couldn't gather in person. My family left for spring break thinking that we would return after a week. And in the middle of spring break, everything was shut down. And so my family ended up going out to Illinois to stay with my in-laws. And we were out there for a couple months, and I remember I had 4 shirts that I brought with me, so I was wearing the same 4 shirts for several months. I had an old laptop. I had maybe 1 toothbrush. So it was very much. I think everybody was experiencing just living through this crazy time. And it was important to me to acknowledge that. And so that my 8-year-old helped me come up with some of the quarantine gags. We looked around the internet for quarantine memes for things that everybody was doing in quarantine and tried to put our own spin on it. But the deeper point, and what's really terrifying about the pandemic is that it's testing our institutions. And it's going to require a lot of institutional rebuilding. I think when I was working on the speech, job numbers were coming out, and the top line number for unemployment was something like 20%. Our graduation happened before protests for racial justice that are now sweeping the country. But people were already starting to think about the tension between public health and personal autonomy that pandemics raise. I've been teaching a seminar that was called Trump and the Law, exploring some of the large themes of the Trump administration. So that had me thinking about the really hard issues that the legal system is facing. And, it occurred to me that, right, like it or not, the pandemic is going to precipitate just a host of changes to our legal system. We all of a sudden, right, we realize that we need a new infrastructure for public health enforcement, right? What do you do if somebody has a contagious disease and refuses to go to the hospital or refuses to stay home and quarantine? How does the law deal with that? So what I said in the speech is that crises sort of shake things loose in the legal system because we don't really have the luxury of debating things endlessly and sort of giving things the extensive deliberation that we often see in Congress or in administrative agencies, just because the need to do something is so great. I compared what's happening now to what was happening during the New Deal, because then as now, we needed to get institutions. And when I say institutions, I mean things like the Social Security Administration or the State Unemployment Office. We need to get things off the ground and running. And that requires, a very special skill that lawyers have, which is, both understanding the practical problem that's to be solved, but also going back to civil procedure, thinking about some of those things we want law to do, You're putting in place new systems, you're putting in place new administrative agencies maybe. And as an attorney, that what you're doing, you're in an unusual moment where you can operate more quickly than usual. You can operate with fewer constraints than usual. But these institutions tend to stick around. The Social Security Administration is created in 1935, and it is with us in modified form today. A lot of the other New Deal agencies are today. And so, what lawyers can do is bring that broader perspective, right? How do we ensure these institutions are fair? How do we ensure that they're effectively implementing whatever the social policy is, while also working to address the problem that motivates legal change? So that's what I was getting at in the speech. And frankly, it's really scary. I have the luxury of sitting in a law school office, or these days in a home office, and thinking deep thoughts and thinking about the way the legal system works. My students, who are far smarter and far more energetic than me, they have to do it, right? I get to think about it, but they're the ones, the boss will be saying, "Hey, how do we solve this problem? How do we do this the right way?" And it's a moment when you go from 0 to 60 just in an incredibly short period of time.
Yeah, I thought it was very powerful. And I know that our fantastic student speaker hit on some of the same themes. I've talked to you a little bit about this, but I think the listeners know that I was at the Equal Employment Opportunity Commission. And during that period of time, there was a decision that came out called Texas Department of Housing and Community Affairs versus Inclusive Communities, which recognized, disparate impact theory in the housing context. Disparate impact theory basically means that you can look at the actual effect of certain actions and try to determine whether it disproportionately impacts certain protected groups. And if that happens, then the other side can come in and try to, determine whether that was they had a sufficient reason for those actions. But it was a very groundbreaking decision. And in the dissent, and I signed the case, but I just signed the dissent from Clarence Thomas. He goes into this really long attack on the EEOC as inventing the disparate impact theory in the first place. And then he singles out Al Blumrosen from our beloved Rutgers Law School, right? He was on the member of the faculty for many years. And I remember thinking that if what Justice Thomas is saying is true, and I think that it's partly true, then that should be taught in every law school. Because when the EEOC was created and first went online, it was created in part of the Civil Rights Act of 64, went online in 1965, it didn't have litigation authority. It was called a toothless tiger. It was ridiculed. It had 4 chairs in the first year, including the son of former President Franklin Delano Roosevelt, right? And what you had instead is you had a bunch of lawyers who came out of the civil rights movement who, and I have all the descriptions, they were hippie lawyers, right? They had, Fu Manchu mustaches and love beads and all that stuff, right? And they had this statute, and they had very little authority to even create administrative guidance. But with all of this, they start putting out guidance. They start just showing up in the appellate courts as amicus, and they really were able to put together this sort of idea in conjunction with, with civil rights organizations, the, NAACP, Legal Defense Fund, most notably, this whole idea of disparate impact, that is such a powerful idea that was recognized by the Supreme Court in 1973. But what I tell the students, and this wasn't in a time like the pandemic, right? This was in a time of plenty right before, I think, the upheaval of the 60s became the upheaval of the 60s, right? And I always tell the students that you always have to bring that spirit of the hippie lawyer to what you do. And that sometimes I think legal education, will focus on the role of the lawyer as applying law to facts as though it were some sort of unerring algorithm, and not necessarily remember that, in large part, it's a creative act. And I think that when you were talking about this in the context of the pandemic, I was really kind of thinking about that spirit that, our graduates from our beloved Rutgers Law School are going to have to go out and create these institutions. And I think they're going to be very well prepared.
Yeah, and I think we're unique in emphasizing that as part of what lawyers do. The tension is that, and I think this is one, Richard Posner, who's one of the great judges of the second half of the 20th century, he always said that the most important thing that law school teaches you is the plasticity of law. In other words, when can law change and when does not law not change? And there's a real fine balance, because there are some claims, there are some arguments that, given the law that we have now, you can't reasonably make, whether to a court or to an administrative agency. One of the most important parts of a lawyer's craft is understanding where the points are that you can push at, and what pathways are open now, and what can I do now to affect legal change. And you mentioned Al Blumrosen, right? One of the things that Al appreciated was that in thinking about legal reform, information is power. Right? The EEOC in its early days did not have rulemaking authority, but it could hire economists that went out and collected data about what was happening in the workplace. It could report numbers to Congress. It could report numbers and information to the courts of appeals. And I think that explains a lot of its influence in those early years. On paper, the EEOC would, right, as you said, virtually powerless, right? It couldn't fine you $10, but it served as a clearinghouse. It served as a place that was surveying what was happening in the workforce. And you continue to see the effects of that work in anti-discrimination law today.
Great. And I think that's a nice segue to our discussion about administrative law, since you've already livened up subject matter litigation. Talk a little bit about your work in administrative law. You've worked on what is known as administrative sabotage, and this is really, really interesting. So just talk a little bit about that, and then we're going to jump in to the news of the day, which was supposed to take up most of this interview, but we got a lot to talk about. So let's do that.
Sure. I mean, so my interest in administrative law comes out of the same place as my interest in civil procedure. A decade ago, I was clerking in the Southern District of New York and on the Second Circuit, and I developed a real interest in the way that legal institutions worked. And I got into my head that I wanted to be a professor and study this stuff. And once you start thinking about procedure, once you start thinking about what's fair, it readily becomes apparent that what happens in court isn't the whole picture. Most people, when they're starting law school, hopefully haven't been involved in a lawsuit. So, right, what they know about the way that a court works is what they've seen on Law and Order. However, we all have interactions with government agencies, right? When you go to get a driver's license, or when you start working and you discover that 30% of your paycheck is taken out to pay for federal income taxes and Social Security and all the other government stuff provides. We're constantly interacting with government agencies. And so when we talk about administrative law, in a broad sense, right, we're talking about the way that agencies do business. How are they structured? How are they set up? And then in a more legalistic sense, how courts oversee administrative action. So if the DMV does something that you think is illegal or is unreasonable or unfair, what's your remedy for that? Can you go to court for that? And what's the relationship between courts and agencies? So for much of the 20th century, the main thing that administrative law worried about was agency overreach. You would have agencies that were going too far. And so we have a huge body of law. And when I say law, I'm mostly talking about court decisions, but also statutes and procedures and the way that agencies are set up, that is designed to keep agencies in check, right? To make sure that they're not too powerful, right? So the EEOC is set up as a multi-member commission, right? There's not a single boss of the EEOC, but it's structured as a commission, in part because of concerns that if there's just one director, right, that person's going to have too much authority, and we worry about whether they're going to abuse that authority. Lots of what agencies do is subject to judicial review, because we're worried that if an agency fines you or if it determines that you violated some law or the other, the agency is going to apply the law incorrectly or follow the wrong procedures. And so we say, okay, if the agency takes away your license as a stockbroker, you can go to a federal court and get review of that. So you mentioned administrative sabotage. The project that I've been working on explores not agency overreach, but the use of administrative power to try and undo statutes, to undo laws that have been enacted by Congress. And probably the clearest example of this is the Trump administration's approach to the Affordable Care Act. Right? As everybody knows, the Affordable Care Act is an incredibly contentious statute. Opposition to the ACA, or Obamacare more colloquially, has been an important part of conservative politics since the statute was enacted. As people might also know, right, in the 115th Congress, Congress tried and failed to repeal the ACA. So what I'm doing in this project is I'm trying to document ways that agencies use their power to undo laws that are on the books. So there's been a lot of rulemaking that the Department of Health and Human Services has done involving the ACA. There's been constitutional litigation trying to persuade courts that the statute is unconstitutional. And amazingly, this is a problem that administrative law hasn't traditionally dealt with. And so not only in this paper am I trying to document the many different ways that agencies can attack statutes that they're supposed to administer, but more prescriptively, I'm making the case that this is something that administrative law should care about, that when we think about agencies being bad, it swings both ways. We have to worry both about the overreaching agency and about the agency that is trying to undo the law that it's supposedly administering.
And that really goes to the heart of issues of democratic legitimacy, because if I understand what you're saying, our duly elected representatives pass a law. It's to be administered by an agency, and then the agency really narrows the law or modifies it in a way that is really inconsistent with what Congress intended.
That distinction is absolutely right. It's just it's a harder issue than it seems at first, because Congress gives a lot of authority to agencies. So when you think about agency sabotage as compared to other things that agencies do, one question that you always have to be asking is this something that Congress authorized an agency to do? There's areas, environmental policy, the way the Social Security system works, where for one reason or another, Congress has said, we're not deciding this. And that leaves a wide range of discretion in which agencies can act. There's others, I would argue that the attack on the ACA is one of them, where the agency is really doing something that's inconsistent with the law that Congress has enacted. And you're absolutely right that raises concerns about democracy, because the agency role on paper is to take the law that Congress enacted and put it into practice in good faith. In practice, agencies have used their resources, have used legal authorities that they have to do the work of undoing or undermining legislation.
Is there a difference between administrative sabotage, as you've defined it, and I think the older term of administrative capture, which is when the regulated industry actually functionally controls the administrative agency? How do those two concepts relate?
Yeah, I think there is. So agency capture, the classic example is, Congress sets up a commission to regulate railroad rates, and the only people who know anything about the way railroads operate are railroad lawyers or economists who work for railroads. And so there's a revolving door that goes back and forth between industry and the agency that's supposedly regulating it. And what you end up with is an agency that is sort of working hand in glove and not paying attention to what it's supposed to be doing according to the law that Congress passed. So that's a concern, because we might say, the agency is using its power in a way that we don't think advances the goals of the statute. Maybe it's keeping out new railroads who want to enter, and setting up regulatory barriers that don't really have any purpose that advances the public interest. Agency sabotage is a step beyond, and like many phenomena of the Trump administration, right, it sort of takes this old pathology that we've thought about and really pushes it. Agency sabotage isn't just about making life easy for regulated industry. It's about killing the legal regime, the overarching legal regime that regulated industry operates under. It's not, we want regulation that's amenable. It's saying, we want this statute gone. We fundamentally disagree.
So I know that we pivoted before and wanted to talk about some very big news from the Supreme Court today. And I wanted to talk about the decision that the Supreme Court handed it down today on the DACA program. You have taught that, you have studied that, you've anticipated and thought about this decision for a long time. So I want you to talk a little bit about the decision, because I think that is a very interesting, very important decision. Oh, shucks, there's someone at the door.
Oh, David, who is that?
Oh my God. It's the Vice Dean. Oh, shoot. Is there something I didn't do? Vice Dean, Rose Cuison-Villazor. Do you want to join us?
Yes, I do. Thank you for allowing me to join your conversation.
And who is this handsome man that you have as a guest?
This is my colleague, Jason Hernandez.
Hi, everyone. My name is Jason Hernandez, and I'm an attorney that runs the Rutgers Immigrant Community Assistance Project, and I provide immigration legal services to students currently enrolled throughout the Rutgers University system.
And so we're gonna talk a little bit about DACA. I just want to brag a little bit about our Vice Dean, Professor of Law, Chancellor, Social Justice Scholar, and she is the founder and director of the Rutgers Center for Immigration Law, Policy, and Justice, a nationally known expert on immigration law. And Jason, of course, you've been doing just a fantastic job here for our community. So let's start out by going back to Professor Noll and tell us about the decision today.
Yeah, so for people who don't know, DACA refers to Deferred Action for Childhood Arrivals. It was a policy that was originally put in place under the Obama administration. What DACA did, there are more undocumented immigrants in the United States than the immigration authorities can realistically deport, given the appropriations that Congress has made to the immigration agencies. And DACA said, look, there's this huge category of undocumented people, both as a way of exercising our enforcement discretion and on humanitarian grounds. We don't think it makes sense to deport so-called dreamers, right? People who were brought to the United States as children and only know the United States as their home. And so what DACA did is it created a process where if you were a qualifying person, you could apply for what's called deferred action. You would show that you met the requirements of the program. And what you'd get in exchange for that was a commitment from the immigration agencies that you wouldn't be put into deportation proceedings. So DACA was somewhat controversial when it was adopted. People claimed that it was inconsistent with the law that Congress had enacted in the Immigration and Nationality Act, and that procedurally it had been issued in the wrong way. And when the Trump administration came into office, the Trump administration attempted to rescind the DACA policy, right, to say that going forward, we are not going to grant deferred action to dreamers. What was at issue in this decision is whether the rescission of DACA was done in a way that complied with the Administrative Procedure Act. And not thinking about whether this is good policy or bad policy, not thinking about what the Immigration and Nationality Act should say about people who are brought to the United States as children, but simply right, whether DACA had been rescinded in the procedurally correct way. And the court's decision, there's a few key pieces, right? First, the court concludes that the rescission of DACA is something that the courts can review because this looks like a policy decision. It looks like the kind of matters that the courts review. And then the key holding in the Supreme Court's decision is that the rescission, taking away DACA, was unlawful because the Department of Homeland Security did not recognize all of the options that were available to it and didn't think about all the costs and benefits of rescinding this policy. So the upshot of this is that, right, the rescission, the taking away of DACA, was vacated and set aside, which means that the DACA program initially set up under the Obama administration continues in effect.
And so what happens next? First of all, were you surprised by the decision?
Surprise is an understatement. I was shocked. Traditionally, administrative law takes a very hands-off approach to questions of enforcement policy. The idea is that choosing which violations of the law to bring enforcement actions about is something that's committed to the executive, both as a matter of the law that Congress has enacted and under the Constitution. And courts are very hesitant, right? Courts are very hesitant to say you should be prosecuting this person or that person. And there's a very important administrative law case called Heckler versus Cheney, where the Supreme Court held that enforcement decisions, the decision to bring an enforcement action or not to bring an enforcement action against one person or the other, are presumed to be outside the scope of judicial review. They're something that courts can't examine. So from that perspective, the courts shouldn't have got involved in reviewing whether DACA was lawfully promulgated, and they shouldn't have got involved in the decision of whether DACA could be rescinded. I was surprised first that the Supreme Court found this reviewable. Then once you clear that threshold, the rest of the decision is a more standard administrative law decision.
So what happens next?
So the court's decision that came down today said what DHS would have to do, right? It would have to identify all of the policy options that are available to it. And the most important requirement that comes out of this decision is that DHS would have to show that it engaged in a reasoned analysis of different ways of proceeding. So all of that takes time. As a practical matter, that means that before DHS does anything else, it's likely going to reach out to affected parties. It's going to want to hear from immigration advocates. It's going to want to hear from DACA recipients. It's going to want to hear from people who think that DACA is a terrible idea. And it's going to have to collect all of that input. But then, right, sort of the crucial break on DHS doing something is that it's going to have to explain both the policies that it considered and why it's choosing one policy rather than another. And that's something that's governed by ordinary administrative law requirements. There's something called arbitrary and capricious review, where courts will look at whether you considered all of the evidence before you, whether you properly weighed the costs and benefits of the way that the agency chose to proceed. And it's something that just takes time. And so simply putting together a change to the DACA program properly is something that will take a number of months.
Well, let me bring in Vice Dean Cuison-Villazor. Vice Dean, do you want to talk about the practical significance of this decision?
Yes, of course. So I definitely agree with what Professor Noll said about some of what the administration might try to do and the challenges with respect to their ability to, in going forward, in trying to rescind it a second time. But for now, we know that as a result of this decision, of this opinion, that the Supreme Court essentially restored DACA, which from a practical perspective means that people who are eligible for it may be able to apply or renew their DACA status. And so it does not mean, though, of course, that DACA will be here with us forever, as Professor Noll has stated. And it's important to acknowledge that much work remains from a policy, advocacy, and legislative perspective. For one thing, through the work that we do at the Center for Immigration Law, Policy, and Justice, it really highlights the need to work more with state and local governments in trying to pass state and local laws that will ensure the protection of DACA and undocumented immigrants and their families. And so the center continues to work with with our partners, community organizations, academics, scholars, and policymakers to try to advocate for a number of different initiatives, including for the state of New Jersey to allow people who are qualified and who are residents of New Jersey to apply for professional licenses, regardless of immigration status. There are 4 other states that allow that, and we would like for New Jersey to be the 5th state to be that inclusive, so that students at Rutgers and other schools in New Jersey, when they graduate, then they can apply for different professional licenses, regardless of their citizenship or immigration status.
So, can you just talk very briefly about the center? You mentioned your center. Can you tell the audience what the center does?
Yes, thank you. So the center was supported by Chancellor Nancy Cantor to create an interdisciplinary center that will work with scholars and advocates, community organizers in trying to create an inclusive and welcoming state for immigrants and their families. And so the center does a number of different initiatives. On the ground level, we provide citizenship classes for lawful permanent residents and really for immigrants who want to learn more about the history of the United States and preparation for the naturalization exam. More broadly, we've been working with groups like Make the Road by Walking and American Friends in trying to pass legislation that will provide privileges and protect the rights of immigrants. So, for example, last November, we testified in support of a law that would allow undocumented immigrants to be able to get a driver's license. And we were very pleased with the state in passing that law. And so that's one example. That's one of the types of policy and legislative type of work that the center does. And then from a scholarly perspective, we work with political scientists and historians in issuing reports that look at both historically and present circumstances in ways that immigration law has affected the rights and privileges of immigrants and citizens who come from mixed status families. So overall, the center partners with various groups, including the various clinics at Rutgers Law School, to assist in protecting the rights of immigrants.
And let's talk really quickly about the clinics. You want to talk about some of the other work in the immigration space going on at Rutgers?
So Jason would probably be the best person to talk about those various initiatives since he works closely with the Immigrants' Rights Clinic and other clinics that do advocacy work for immigrants. Jason, do you want to talk about the
Sure.
work that you do?
Sure, it would be my pleasure. So Rutgers Law School has several clinics that provide services to the immigrant community. We have the Immigrant Justice Clinic, which is based in Camden, and that provides services to Southern New Jersey. It actually partners with the Child Advocacy Clinic in Newark to provide immigration consultation and legal services on a statewide basis to all youth that are in the custody of the New Jersey Department of Protection and Planning. And so additionally, we have in Newark the Immigrant Rights Clinic, and that clinic provides services to the community in Newark, but lately has prioritized service to detained immigrants in the state of New Jersey, thanks to funds that were made available through the state. My project itself is also part of the clinic. The Rutgers Immigrant Community Assistance Project provides immigration legal services and consultations to students on all 3 campuses, Newark, New Brunswick, and Camden. Additionally, we provide educational programming to the campus community and throughout the state of New Jersey. We were founded through pilot funding dollars from the President's office, as well as the chancellors on each of the 3 campuses to begin building infrastructure to support undocumented students enrolled across the campuses. And during that time, we've served over 200 students. It is certainly a unique position for Rutgers on the East Coast because we're positioned in the state of New Jersey. We have a larger population of immigrants on this East Coast, but additionally, our state has provided for in-state tuition rates as well as state-based financial aid to be available to undocumented students who qualify for state residency regardless of lawful presence in the United States. And as a result, we have seen a larger population of undocumented students accessing higher ed. So Rutgers is basically a pilot program for the East Coast of the United States, providing services that we see in large part in California up to this point, out of universities providing campus-based legal services.
Thank you. Talk about what the decision means today for our students.
So I can tell you already, I've received numerous emails from students telling me they have tears in their eyes, which is it's bittersweet in some ways because it is this is not a resolution, but certainly it does buy many of our students more time with stability in their lives. Many of them are graduating and beginning their professional careers, and were uncertain whether they would have work authorization over the course of the next 2 years. So this certainly offers them some measure of comfort. DACA for many people is a life-changing benefit. For individuals who qualify for DACA or our students, this allows them to work lawfully in the United States, to access driver's licenses in states that don't permit undocumented folks to have driver's licenses, to access a variety of other local resources. And so the fact that DACA remains is certainly life-changing for many of our students who have been in limbo and unfortunately will continue to be in limbo. But I think these short windows of stability are what we can hope for during this sort of unpredictable time.
That's wonderful. Anything else on today's DACA decision that you want to add to the conversation?
I think one thing that was one part of the opinion that has not been mentioned yet is there was an equal protection claim that the majority rejected, and so and Justice Sotomayor, in her concurrence, would have found that there was an equal protection claim, or at least would have examined that claim. By contrast, the majority, or rather the four of the majority, ruled that there was no equal protection claim that can be examined at all. Part of the claims here by the plaintiffs was that DACA had a disparate impact on Latinos, and it was the Supreme Court, the majority, or I keep saying the majority, but it's really just the four of the majority, who said that many of the undocumented immigrants in the United States are Latinos, and so therefore, one of the reasons why the disparate impact theory would not work is because of those statistics. So I was disappointed myself in how the court addressed that part of the opinion. So while I'm happy about the outcome and the use of administrative law here, I thought that this was it was disappointing that the equal protection claim did not survive.
One other note that I would just like to add is that new DACA applicants to apply. And so we have 15 to 18-year-olds who were never able to apply for DACA, who otherwise qualified, but for the rescission. And so this will also expand the class of individuals who were covered by DACA for future discussions pertaining to the Dream Bill, because now there'll be a new population of young people who come to rely on DACA who have not been able to access the program for the past 3 years.
Well, Professor Noll, anything you want to add?
I mean, I think just to echo what everyone else said, this is a decision that continues the status quo. It doesn't answer the question of what immigration reform is going to look like. One of these years, Congress is going to have to take up the issue to finally deliver some certainty.
Very, very big day. Thank you, Vice Dean and Mr. Hernandez, for popping in. I'd like to invite you back for a more extended discussion, but we definitely appreciate you coming in on this very big day. So thank you so much.
Thank you for inviting us.
Pleasure to be here.
And Professor Noll, I have a couple more questions.
Sure.
I know one of the things we're going to talk about is complex multi-district litigation. Can you do that in 30 seconds?
We're going to have to do another podcast. It's another of the favorite things that I teach and that I research about. The 30-second version is that when you talk about complex litigation, you're talking about how does the court system respond when things go really wrong, right? Merck releases a painkiller that doesn't just injure 5 or 10 people, but causes tens of thousands of people to have an elevated risk of a heart attack. Or Volkswagen releases a supposedly clean diesel car, where it turns out that it's not actually reducing less emissions. The engineers have just programmed it to fake emitting low emissions when it's being tested. So all of a sudden you have thousands and thousands of people asserting claims, asking for money, asking for court orders, telling the defendant to do this or that. How's the legal system deal with that? How do you, right? That's the basic problem, is right. How do you deal with litigation and lawsuits? Not when you're talking about suing your neighbor, but when you're talking about industrial scale wrongdoing.
Great. Now, we know that we have listeners who are lawyers. We have listeners who are not lawyers. We have listeners who are considering going to law school. To close, what do you have to tell them about Rutgers? Why Rutgers?
So I have to say, we're a really unique law school. They should come and visit and get a feel for what the place is like. One thing that distinguishes us is that although on paper we're a pretty large law school, up there with Harvard and NYU and the other bigger law schools, the fact that we're in 2 locations means that your day-to-day experience is somewhere that is, very small, where you know most of the professors, most of the people that are in the building. Another thing that Rutgers does particularly well is integrate people who are in practice and are doing actual legal work with the more theoretical and the more scholarly part of our curriculum. And there's just a really wonderful interchange that comes from the fact that you have people who are doing real cases in the building. The fear becoming an academic is always that you're going to go into the ivory tower and you're going to lose touch with the way that things are really happening in the real world, and you lose that connection to practice. I know very few people at Rutgers who have that experience, because there's so many people who are representing clients day to day and integrating the scholarly side with the practice side.
Thank you so much, David Noll, Professor of Law at Rutgers Law School.
Thank you.
Thank you so much. The Power of Attorney is produced by Rutgers Law School. With 2 locations minutes from Philadelphia and New York City, Rutgers Law offers the prestige and reputation of a large, nationally known university with a personal, small campus experience. Learn more about Rutgers Law by visiting law.rutgers.edu.